going to discuss about dying declaration, which is very important. So short note, so let's start. Dying declaration, which is a statement which is made by a person who is on verge of death regarding the facts that resulted in his death. It is an example of hearsay evidence. General rules are compos menti, that he should be mentally well, his mental function should be normal, and the person should be conscious. This is known as compos menti. Okay, so doctor should certify that the person is conscious and his mental functions are normal. Executive magistrate should be called for recording the declaration. But if there is sufficient time, if there is no time, we should not look for a executive magistrate to come. We should follow further, and the doctor, police, or any person who are there, who can record the declaration in presence of two witnesses. So two witnesses should be present, must be present. Evidentiary value maximum when it is recorded by the magistrate. Oath is not administered because he is on the verge of death. So we have the belief that the who is going to die must will speak the truth. Okay, only speaks the truth. Recorded in the language spoken by the victim, can be recorded in any form, written by the person himself, video recorded, or written by other person. No alteration of the terms and phases. Whatever the person says, we should it should be in exact terms and phases. No alteration should be there. No prompting or suggestions. A statement should be free and spontaneous. No opinions or judgments. Statement must be on the facts. No leading questions. We should not ask him the leading questions like okay, what happened, this happened, that person came from the behind of you, he did like this to you, like that. You should not ask. Yes or no question should not be kept. Whatever he says, we should not interrupt him, and in exact terms and phases we should record it in the form of written form, or we should ask the person, if he is in the position of writing, we will ask him to write and give the statement. Okay, mainly magistrates one is very considered. Verbal statements, it is not necessary that the word should be spoken if the declarant is unable to speak. So you may ask, if the declarant can't able to speak, what then we will do? So we will ask him to make signs or gestures to the questions. Whatever the signs or gestures he will keep, we will record them, and they will be shown in the video form in the court. Okay, the investigating police officer should not be present when declaration is recorded to avoid undue influence. Who is the investigating officer? The police officer should not be present there in case of declaration, because he may influence the person to make false statements like that. Signature or thumb impression of the declarant obtained. Declaration should be signed by the doctor and witness and forward to the magistrate. Treatment, the declaration will be completed, and it should be signed by the doctor who is recording, who is doing the operations or surgeries of the patient, and the two witnesses signature should be must, and it should be forwarded to the magistrate. The treatment should never be stopped or delayed to obtain the declaration. It is must. Treatment should be continuing. If the declarant survives by fortune after dying declaration, it will give corroborative evidence, and the declarant should be called for oral evidence. Okay, so if the declarant survives, we will call for the court for oral evidence. If the declarant dies during the process, it should be noted and submitted. It has legal value. Okay guys, this is about dying declaration. Thank you.